the victims in this case lost nearly everything that they own. And so, Your Honor, we're asking that you protect the community from these types of crimes and sentence the defendant to 15 years in prison.
This case centers on a massive theft involving hundreds of thousands of dollars in lost personal and military-related property. The defendant claims he unknowingly bought stolen goods in sealed boxes, but the court is now weighing intent against circumstances.
All right, we are here for sentencing. A jury found you guilty. Just one moment. And they found you guilty of the offense of theft, $300,000 or more as charged in the indictment. Have both parties had a chance to review the PSI report? State.
We have, Your Honor.
Defense.
Yes, Your Honor.
Any corrections or additions to the PSI report? State.
No, Your Honor.
Defense.
No, Your Honor.
All right. State, what are you requesting?
Your Honor, we're asking that you sentence the defendant to 15 years in the prison.
All right. And the reason?
Your Honor, the defendant was convicted of a first-degree felony offense in this case. Reading the TAP evaluation, he's shown no remorse for his actions. He doesn't say this was the result of being under the influence of drugs or alcohol. His story about how he says this happens is just not credible. Doesn't jive with the evidence that we saw at trial. He says that someone offered to sell him $300 worth of items, over $300 worth of items for $600 to $800. He says his friend brought the trailer to him. The evidence that was elicited at trial indicated that a window of the truck was broken. So it's pretty clear to me that he knew these items were, the very least, he knew these items were stolen. But Your Honor, what he's convicted of is theft. And I guess the other part of this, the TAP evaluation, they talked about his home life a little bit. He says he has regular contact with all his kids, but evidence elicited at the trial was he's not paying any kind of child support to Edith Serrano. That was one of the victims, you may recall, Your Honor. Or I'm sorry, one of the witnesses at the trial, Your Honor. I know you were presided over this case, Judge, so you remember the testimony, but Terry Kirkbride and his wife are moving from California to Florida, and they lost almost everything as a result of this theft, Your Honor. But what Terry said on the stand is what really stuck with me. And what he said is the hardest part about this is that he lost things in this theft as a result of this theft, as a result of the actions of the defendant that cannot be replaced. So the hardest part of that for him were the photos that are just gone forever. The things that he inherited, the things that his wife inherited, they're gone forever. Items from his military career that are gone forever, damaged or lost. And so that's what I want to emphasize to the court. And the other part of the thing I want to emphasize to the court, Your Honor, is we're asking for this sentence to protect the community from these types of thefts. This property crime, I think, especially folks who are involved in the criminal justice system, we can get sort of jaded and think, well, nobody died, right? But these crimes are very serious. And the victims in this case lost nearly everything that they own. And so, Your Honor, we're asking that you protect the community from these types of crimes and sentence the defendant to 15 years in prison.
All right, defense.
Judge, if the court recalls the facts of the case, I think Mr. Lozano's explanation is perfectly plausible. There was absolutely no evidence presented by the state in the trial of the case that he was present when that truck was stolen, whether he ever drove that truck, ever had contact with that truck, it was ever on his property. His suggestion that the guy brought the trailer to him to see if he wanted to buy it is consistent with somebody who did steal that property, trying to go and pawn it off on people. Him paying $600 or $800 for what was the contents is because all the valuables were already gone. All that was left was a bunch of stuff that after whoever stole it, poured through it. He admitted, yes, my print is on the trailer because he showed it to me and he wanted more money than I could afford. And so I didn't buy it. He offered me the other things that were there. The complainant specifically testified in his testimony, the things that were at Mr. Lozano's property that they recovered were of little or no value, right? If you look at the PSI report, when they go to the restitution, it says approximately $300,000. How can you approximate that when he's already been found guilty by a jury? Well, this court knows why. It's because her math was a mess. The complainant testified in the trial of the case that he agreed in writing a contractual agreement with the insurance company to settle for $240,000. The theft statute is very, very clear. It's the value of the property at the time it's stolen, not what you paid for it years before. So when you read their exhibits, and the jury obviously never did, they put no attention to the real evidence in the case. They felt bad for the complainants. I feel bad. We all do. They suffered a great loss, but they didn't prove he was the one who did it. They proved that he was a party to being in possession of some of the stolen property. That's why we had a jury charge all the way down to a state jail. That was the appropriate charge. And this case is ripe and full of appeal issues, especially on the issue of the value and sufficiency of evidence. This case does not merit a day in prison. I get it. It's a big loss. But if you look at the exhibits, and I was going to bring it to you, but it's in the court's file or court board's file. USA went through an exhaustive list, and he says I spent months and I kept updating it, telling them all the things that I lost. They put the retail value, they depreciated it down to the actual cash value at the time of the loss, right? He signs an agreement, accepts the check saying $240,000. And that included the truck.
All right, so just so parties know, I'm not going behind the jury's verdict.
I'm not asking you to.
Yeah,
I'm just saying the punishment should fit the crime. Okay. The jury did what they did, and that's for another court to look at, whether there was sufficient evidence for their verdict. But my suggestion is, if they've proven that my guy drove off with the truck and the trailer and he had gotten rid of everything, I can see that this is a different case. There's absolutely no evidence that was presented to suggest that. And his explanation fits squarely within the facts that were presented in this case. So I get it that there's restitution. My client is going to have a lifetime consequence because of his resident status of potentially being excluded from this country. So he is going to get punished severely by this court and probably another one. So all that being said, Judge, we'd ask the court to sentence him to a term of probation. We'll pay restitution to their number as best he can, as long as he can. But that's the appropriate sentence. If we're going to start locking up every person who goes to a flea market and those people that come into property illegally and they get it in their possession, we're going to start sending them all to prison. We don't have a big enough jail for that, Judge.
All right. Is there anything you wish to say?
Yes.
All right. You want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Jose Lozano.
All right. And make sure you keep your voice up so the court reporter can hear. Who's the name of the friend that gave you these items?
Who's the name? I don't know his name. They called him.
Well, I mean, you say he's your friend.
Well, yeah, but
And you say you received a phone call from a friend.
yes, should have wrote it down.
All right. So here's my other question. The items, because there were some items that were related to his military career. When you saw the name of a person's name on military paperwork, what did you think?
At the point already, I had the stuff in my house. I didn't know what to do with it. No, it was there. I bought it. It was in boxes when I bought it. By the time I got to open it, I saw the stuff.
So how much money did you pay for this stuff?
About $800. Whatever was in the trailer, I got it off. About $800 and $900.
Did you look through everything before you paid $800 or $900?
Boxes.
So you just take a boxes sight unseen, sort of like Storage Wars?
Oh, yeah.
All right. And so you don't know your friend's name who phoned you. According to you, it says that you were home asleep on this date and you received a phone call from a friend.
They call him Chaparro, but off the top of my head, I can't remember his name right now. I'm sorry.
Oh, no problem. I just wanted that cleared up. All right. This is what the court is going to do. Court is going to sentence you to 6 years in the prison, give you credit for any time served. With regards to the amount, the court does not deal in approximations. So for the court, there is no restitution because there is nothing here to suggest a restitution amount. It just says approximately $300,000. There's nothing I can do with that. And this trial was on March 21st. I'm sorry, just one moment. Yes, March 2024. So by that time, there should have been some amount to the court. So I'll give you credit for any time served. Is there anything else with regards to sentencing, State?
Judge, is the defendant's birthday May 1st, 1998? Is that right?
You can ask him.
Okay. Is that your birthday, sir? May 1st, 1998?
Yeah.
And Judge, would you incorporate the evidence at trial as to the value? Would that be something you'd be willing to do?
No, because again, the amount that's listed in the PSI report is approximately $300,000. And then defense counsel is correct with the amount that the complainant settled for. And I know how insurance companies do sometimes.
Probably
The amount, the amount the insurance company settled for was $240,000. So this is where we are.
If I could, just one last thing on the record. I just wanted the court to be aware, and the record to be clear, that approximation comes from the complainant. The PSI officer called the complainant to ask him that number, and that was his response,
Yes.
even after his testimony that was presented to the court.
I'm not ordering restitution unless there is some sort of deductible, which the court has not received any information on a deductible amount. So the court will sentence you to 6 years in the prison and give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honor, we just have victim impact fees.
I do, Judge.
Yes.
We will be filing notice of appeal and a request for an appeal bond. Do you want to take that up today or?
Oh, you have to file the motion and the court will take that up. So if you could have him fill out the trial court certification.
Well, they're going to be filed today. That's why I'm asking if he could be kept in court today so we could address it, or.
It's going to have to be another date. All right. If you could have him do the trial court certification, so I could do that now, please. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
All right, you have a right to an appeal as this was a jury trial. And counsel, once you file that motion, Ms. Ferguson will give you a date.
Yes, sure.
All right, you said there's brief impact.
Yes, ma'am.
All right. Are the parties here on Lozano? If you could start your video, please. All right. Mr. Kirkbride?
Yes.
All right, you may begin with your impact statement.
Okay, I had no idea what to expect in this matter, but I see the sentencing's already been done. I'll just try to keep it short. I think the court's already heard most of our story, but I'll just go down the quick history. I mean, when we made our decision to move to Florida, it was to be near kids and grandkids. It was a pretty tough decision. I lived in California all my life up to that point. Sold our home, gave away pretty much all of our possessions that could be replaced, like furniture, refrigerators, that type of thing. All of our most precious items were packed up very carefully. It took us almost 3 months to get everything properly packed and wrapped. And I bought a 24-foot enclosed trailer, and that's where we packed everything in. On our journey to our joyous move to Florida to start a new life, we made it as far as San Antonio. And of course, from that moment forward, December 4th forward, it's just like our world was turned upside down. It derailed our whole joy of the move. And what was supposed to be looking for a home right away turned into almost an 8-month endeavor because we were dealing with all of the aftermath of the theft. I'm a combat veteran. One of my diagnoses is PTSD, so I was already dealing with that. And then this just totally derailed me and my wife and left us kind of in this state of like, what next? As we put the pieces together, keep in mind, it was 3 years, 3 months from the time of the theft to the time of the trial. And they had some 22, 23 resets. Each one of those resets represented to us is we had to juggle our lives around the schedule of the court. We gave up family vacations, gave up visiting sick family members. We did a lot of things during those 3.5 years, 3 years, 3 months that just kept this thing going. And now we're here at the final part of the sentencing and all that. And I feel for the for both sides. I feel for Mr. Lozano and how this must be for him, but I also got to understand what it was like for us. These weren't just things that you go to the store and buy. This was our life. My wife is a Native American studies. She had all of her research that was in those boxes that are gone, all of my VA records, all of our photographs of our family from the past, videos of the kids, all those things that cannot be replaced, along with all my military accolades that are gone. The impact was great. And I am glad that we're finally at a point for us anyways, where we can just kind of turn the page. I think that's enough said.
Calling 2022 CR 7318, State of Texas versus Andrew Hutkins. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense? Are you Mr. Hutkins? Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Hutkins, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Your Honor, I couldn't remember if there was a enhancement allegation, but not when you proceed as presented.
All right. Mr. Hutkins, I'm showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of marijuana, 4 ounces to 5 pounds as a state jail felony? Range of punishment is anywhere from 180 days, which is 2 years in the state jail facility, and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call on the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to $10,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Hutkins, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, there's to be a $1,000 fine. State recommends deferred adjudication, restitution of $57, and to the Bexar County Crime Lab. Did you understand that to be the plea?
Yes.
State,
Yes, Your Honor.
defense?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal. Paragraph, did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 4 years. There'll be a TAP evaluation and 160 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No confidence.
State any evidence.
Your Honor, state all proceeds as if it won in all attachments. No objection, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I do.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Oh, I'm so sorry. Court has reviewed states, it's been a long day. Court has reviewed states exhibits 1 and attachments. The court is finding there's sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Anything you wish to say on behalf of your client?
We just have this report follow up.
All right, Mr. Hudkins, do you have any children?
No.
What do you do for a living?
Right now, me and my wife, we just moved down here about 4 months ago, 5 months. We work at the wash tub.
Okay.
So it's just something for right now.
Where did you move from?
Nevada.
What brings you to San Antonio?
Her family stays out here. She wanted to be with her side of the family. So I was decided to come out here and give us an right.
What's her name?
April Voorhees.
Who is Leanne Palacios?
I'm sorry.
Who is Leanne Palacios?
Oh, that's gonna be my brother's wife or girlfriend.
So what family do you have here?
Oh, just my brother, but her family's down here.
Okay. If you're drug tested today, what are the results going to be?
Nothing. I don't have it.
All right, anything else from either side?
No, Judge. I think those we sent it.
All right, court will sentence you to $1,000 fine. That'll be probated. 4 years deferred adjudication. 160 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. $57 restitution to the Bexar County Crime Lab for drug testing. Regular UAs, regular reporting by Zoom or in person. Field visits 1 time per month until further notice. Proof of employment. Within 30 days. There should be no employment as a home health care provider or with minors. Does, did you say your girlfriend? Or I'm like your girlfriend who you're here with.
Yeah.
All right. Does your girlfriend have any children?
No.
Are there any minors that live in the home?
No.
All right. Probation, is there anything else he needs?
Your Honor, did you say regular virtual or in-person reporting?
Yes.
That's all. Thank you.
You're welcome. Is there anything else you need from the court to be successful, Miss Probation?
No, ma'am. I'm just trying to do the right thing.
Sean, it's not a mistake, it's a choice. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, good luck to you. All right, and after Eddie Baldwin, then I'll take up the matters on the parties who are here for trial.
Hello, Your Honor.
Hello, how are you doing?
I'm doing good.
Wait a minute, let me put on my glasses. Is that SpongeBob?
Yes, it is.
Oh, you know, there's a rumor. And I think the facts will bear this out. That the Krabby Patties are made from crabs. Oh. And that's why you don't see any crabs in SpongeBob's world. In Bikini Bottom. Have you ever seen a crab in Bikini Bottom? Except for the crab patties?
Mr. Krabs. Mr. Krabs.
Mr. Krabs is killing.
But he guards that recipe.
He does.
You got
That's right.
something there.
Yeah.
What? That's a really.
Sorry. You know, all evidence points towards that. And don't get me started with the squirrel. I mean, everybody just was fine with her putting on her helmet going down there. But okay. I like SpongeBob,
Thank you.
but now that song is gonna be in my head. All right, the court is calling 2026 CR 0000656-02, State versus Eddie Baldwin. Can I have parties announced?
Lauren Espinoza for the state.
And Valerie Headland for Mr. Baldwin.
I'm so sorry, you're gonna have to take that to the court, yeah.
Oh, yeah.
And are you Mr. Baldwin?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Baldwin, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes.
State, are you proceeding on the indictment as presented?
I do believe so, Judge, yes.
Mr. Baldwin, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, to charge with the offense of robbery, that's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. You have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call on the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Baldwin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,000 fine probated. The state recommends community supervision. They're taking in consideration 2025 CC 016045. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be 100 hours of community service restitution, no contact with Judy Apolinar or any Cricket Wireless in Bear County, MRT, and the felony theft course. Did you understand those are recommendations from the state?
Yes,
And
ma'am.
the court does not have to follow those recommendations.
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
No objection.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call on the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
No, Judge, he was in custody for quite a few minutes
Yes,
before
ma'am.
you pointed out. So I think he's had plenty of time to reflect, and I think he's gonna do well on probation.
Why did you do this?
I was on drugs. Yes,
Okay.
ma'am.
So are you living with someone? Do you live by yourself?
I live with my mom.
Okay. Do you have any children?
I got one, a
Right.
son. Yes,
And
ma'am. He's
age?
5 years old.
Okay. How far did you go in school?
I made it to the 10th grade.
Okay. Have you obtained a GED or
No,
anything?
ma'am.
When's the last time you had employment?
I'm employed right now, but before I got locked up at this time, I was with UPS. And then when I got with them, I got locked up and they fired me. So as soon as I got out, I started working with my brother doing general labor, and I've been with him ever since.
All right. And I'm assuming UPS is not gonna hire you again?
No, ma'am.
Okay. All right. The court is gonna sentence you to 4 years in the prison, suspended and probated for 4 years. There's regular reporting by Zoom or in person,
Yes, ma'am.
regular random UAs, proof of employment within 40 days, no employment as a home health care provider or minors, and what drugs were you addicted to?
I was on methamphetamine.
Okay,
Yes, ma'am.
all right, we'll do a referral to felony drug court. And that can be out of custody. And if not accepted to felony drug court, then do a TAP evaluation out of custody, follow recommendations, but if they recommend inpatient treatment, we'll start with outpatient treatment. Take in consideration 2025 CC 016045. There is $1,000 fine, probated. No contact with Judy Apollinaire. Do you have service with Cricket?
No, ma'am.
All right. Is there any need to ban him from all crickets? Do you have a cell phone?
Yes, ma'am.
Who is it? What's the,
Metro PCS.
all right. All right, there's to be no contact with the cricket at that location.
Yes, ma'am.
And that is, let me see.
Address if needed, Judge.
Hmm?
I can provide the address if needed.
Oh, yes, please.
2118 South Zarzamora, number 450.
You said number 450?
Yes, ma'am.
Do you have the zip? Is it 78201?
One.
All right, wait.
Yes.
78201. So you're not to go to that cricket, okay?
Yes, ma'am.
There's going to be 100 hours community service restitution. And 25 hours will be deducted. I'm sorry, not 25, 50 hours will be deducted if you obtain your GED or some type of trade school certification.
Yes, ma'am.
The remaining hours will be deducted at 1 hour per completion of sober support meeting. Field visits 1 time per month for 8 months. And are you going to remain living with your mom?
No, ma'am.
Okay. Make sure that you provide stable housing to probation. If there's an issue with stable housing, you need to let them know about it.
Yes, ma'am.
The felony drug court will be really great for you because they can help you with that.
Yes, ma'am.
And then you could see a lot of people stay at Tiny Village in San Antonio. I think it's called Twin Towers or Tiny Twin, something of that nature, but you can Google it. All right. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
No,
All right. If you need anything, be sure to let probation know and just be honest with felony drug court because I think that would be a good placement for you.
yes, ma'am.
All righty. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to your attorney, okay?
Yes, ma'am.
And it's called Town Twin Village.
Yes, ma'am.
And at the Town Twin Village, you may not be in the age category because they have certain restrictions. And I think it's sort of like people in their 50s. However, they do have a place where people are homeless.
With their
You can get
children.
laundry, your laundry done,
Yes, ma'am.
you can take a shower, and I think they allow you 10 minutes, which other places, they tell me only allow 5.
Yes, ma'am.
And they provide meals, 3 meals a day.
Yes,
Okay.
ma'am. Yes, ma'am.
All righty. All right, well, good luck to you.
Thank you so much.
You're welcome. Have a good one. And just stay in touch with probation, okay?
Yes,
That's what
ma'am.
I told him. That's the worst thing you can do is just fall off the radar, so.
And trust me, those are crabs in those crab cages.
Yes, ma'am.
All right.
We be able to use.
Okay.
Okay.
Instead of sending him straight to prison, the judge suspended a 4-year sentence and placed him on probation with drug court, strict supervision, and life-changing conditions. One mistake put him here, but the next choices will decide if he stays free.
All right, the court is calling 2026 CR 0000976. State versus Isaias Reyes. I'm sorry.
Sorry, good, Your Honor.
All right, could I have parties announced?
Lauren Espinoza for the state.
Robert Barron from Mr. Reyes.
And are you Mr. Reyes?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Reyes, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
Review, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Reyes, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Reyes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
I understand, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $1,000 fine probated. State recommends deferred adjudication. This run concurrent with 2025 PF 37473. Did you understand that to be your plea?
Yes, Your Honor.
Defense and state.
Yes, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be 120 hours of community service restitution. No contact with 12280 State Highway 16 South, San Antonio, Texas 78224, MRT and the DOEP. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence?
Yes, Your Honor. State offers State's Exhibit 1 in all attachments, and also regarding that PF number, I have the filed CC number for
All
the
right.
court.
Yes, and what is that number?
2026 CC 006893.
Any objection to the court writing that in the plea?
No, Judge.
All right, so you say 226 CC 006893?
Yes, Judge. Thank you.
You're welcome. All right, and then state you're offering into evidence
State's Exhibit 1 in all attachments, Judge.
and no objections?
No, Judge.
All right, state you may be excused.
Thank you.
Thank you. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibit 1 and attachments, and the court will review the same. Right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client? So this location, what's the name of this location?
It's flea market.
Okay, because they were talking about a dance floor. Is there,
It's,
oh, so it's the dance, they have dance?
yeah, it's like a flea market where everybody goes and like they got like their own dance floors.
Okay, because I was trying to, because I didn't see the name. So what else do they have at this flea market other than the dancing?
I just people shopping by like clothes or food.
All right, and what time is this alleged to have happened? Was it during the day or?
I really do not remember, Your Honor.
Okay. So this is a possession less than a gram case. If you're drug tested today, what would the results be?
Negative.
Why does it take you a long time to say that? So here's the thing, I need you to tell me the truth because I can tell you right now, I'm gonna follow your agreement, but your attorney will tell you, I'm trying to give you conditions that are gonna help you. So if you're gonna be positive, let me know because they're gonna drug test you.
No, Your Honor. I won't be positive.
If you even think you're positive, it's okay to say so.
No, yeah, I understand, but I'm positive that it's gonna become negative.
I'm sorry, what?
I'm positive it's gonna come out negative.
Oh, okay. So when's the last time you used?
Believe like it's been a month or so. Because I was at a stage working
Okay, and do you, oh, what do you do?
construction.
Do you have any children?
No, man.
So state, with regards to this no contact, he's telling me that location is a flea market.
Yes, Judge.
Do y'all have any objection to him having contact during the daytime? I don't know what time this dance happened.
So the report time, Judge, was 15:33, which would be, what is that, afternoon
Three,
time,
yes,
3
3
p.m.
So,
But whatever the court sees fit is fine.
well, I can do you can have contact with that location, because I know with the flea market, sometimes people go there to buy things, but it'll be from, what time does the flea market open?
Like around 9 in the morning.
9? So it will, I'll say like from 9 to 12, you can have contact, okay? But don't go to the dance floor.
Understand, Your Honor.
All right. Okay. This is what the court is gonna do. There's $1,000 fine, probated, concurrent with 2025 PF 37473, which is the same cause number as 2026 CC 006893. Regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. And with regards to the regular random UAs, he can do that or do the patch. Sometimes the patch doesn't work well if you're working in construction because of the heat. Your attorney can explain to you about that. There's 120 hours community service restitution. I'm gonna order the DOEP course. Once that's completed, 60 hours will be deemed satisfied. The remaining 60 hours, there will be an hour deducted for every completion of the sober support meeting. There's allowed contact. Monday through Sunday. Well, I'm sorry, I'm just gonna say daily contact from 9 a.m. to 12 p.m. at 12280 State Highway 16 South, San Antonio, Texas 78224. There's a TAP evaluation out of custody. Follow Rex. But if it says inpatient treatment, start with supportive outpatient treatment. Probation, is there anything else?
For those hours that you can't enter that location, I mean, that it's allowed to enter, can you give me those hours one more time?
9 a.m. to 12 p.m.
And field visit,
We'll do field visits one time per month for 3 months.
nothing else, Judge.
All right, is there anything else that you need from the court to be successful? Did you, and I'm sorry, no possession of firearms. And the reason why I'm doing that is because you have an unlawfully carrying case in misdemeanor court, I'm assuming. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because it's plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand? All right, good luck to you, okay? Thank you. All right, on this case, I mean, I've already informed defense counsel, you all waited too late to file a motion to withdraw. We're at jury trial stage, so.
Well, Your Honor, if I may,
Yes.
we were hired on this case in November. Mr. El-Gadrab failed to appear to a hearing back in November.
Because he was currently in a hospital. We were waiting for documentation, and documentation was provided.
Yes. And documentation I don't believe documentation was provided, Your Honor. We attempted to reach out to Mr. El-Gadrab, but there was no communication returned. We lost communication as a courtesy for him to attempt to reestablish communication. We waited a couple of months. We filed a motion to withdraw in January. I attempted a few times to address that with the court, but because there was an active warrant, that was not considered until he was arrested and brought before the court. And the first opportunity we've had to address that motion back in January in front of the court was today. So that's why the motion to withdraw is being urged today in this matter.
When were you all hired for this case?
When?
When?
November 11th, I believe. Yeah, it was November 11th we were hired. We filed a notice of appearance on November 11th, which was a holiday.
Okay, so you all filed it on November 11th of 2025?
Yes, sir.
All right, so he had previously had an attorney representing him before you all were hired. So this case is going to trial and you're his attorney. So y'all are gonna be back tomorrow.
I never request for the trial either, man. I never request for trial either.
All right, well, we'll see what happens tomorrow.
Your Honor,
Yes.
like I said, Mr. El-Gadrab failed to cooperate and maintain adequate communication with us. He, at that point in time, severed any sort of attorney-client relationship at that point. We've had no opportunity to address the case with him, talk about any possible defenses. Additionally to that, we learned that he is not a U.S. citizen. I have not had the opportunity to discuss matters with him in relation to Mr. D11.
I'll see y'all back tomorrow for jury trial on April 29th, and whatever y'all need to discuss with him, discuss with him. Because what I do know is he had been represented by an attorney at the beginning of May of 2025. Then you all were hired and now you all went off. I mean, his trial is upcoming and he's saying that he doesn't want a trial. So I'll see you all tomorrow. All right, who's next?
Your Honor, if I have,
Who do you have?
but I don't have any more, Your Honor, but I have more to present to the court as to why.
Sure, we can present more. All right, the court is calling 2025 CR 004768 State versus Mahmoud Al-Gadrab. If you'll come back. Can I have parties announced?
Lauren Espinoza for the state.
Mario Moreno for the defendant, Your Honor.
All right, and are you Mr. Al-Gadrab?
Yes, ma'am.
All right, the court will note for the record, the defense off the record told the court that they were seeking to withdraw from the defendant's case. The defendant previously had an attorney, May 2025. Defense counsel was hired according to the defense, November 2025. We are now here for a jury trial, and the defendant has been in custody since, I believe, what's he placed in custody? I'm sorry? March 8th. He's been in custody since March 8th of 2026. And so this is scheduled for jury trial today. And then, I'm sorry?
I was not in this county.
That's okay. You were in Hardin County? Yes, since March of 2026. This case is set for jury trial today. The case was previously set for jury trial on January 7th, 15th, 2025. And then it was reset for jury trial on November 12th, 2025. Defense counsel was hired, and when that case was set for jury trial on November 12th, 2025, it was set on September 15th. I'm sorry, for the record. It was set on September 15th, 2025 for jury trial and a plea deadline date on November 12th, 2025. And then defense counsel was hired in November 2025. And so this is set for jury trial. Defense, you wanted to place something on the record?
Yes, Your Honor, and I was not aware that we weren't previously on the record, so I will
That's
restate
okay.
everything I had previously said. So Mr. Elgadrab did hire our firm as a Martin and Associates law firm back in November 11th, 2025. There was a jury trial scheduled at that time, but Mr. Elgadrab did not appear for that date. We were informed that he was in the hospital and would provide, and this was not information that was provided to us directly from Mr. Elgadrab. We were told by an associate that he was in the hospital and would provide details to provide to the court as to potentially excuse his not appearance on that day, but we did not receive that information. We lost contact with Mr. Elgadrab and he failed to maintain and cooperate with our law office. Thereafter, we, in order to give him some sort of benefit of the doubt and give him some chance, we held off on a motion to withdraw until January of 2026 because we failed to establish contact with him at that point. I attempted several times with the court to present a motion to withdraw earlier in the year after it was filed on January 26th, but the court refused to hear that motion while Mr. Elgadrab had an active warrant and was not in custody. So it wasn't for any lack of our firm or the defense attorney's attempt to obtain an alternate attorney for Mr. Elgadrab at that point. We were told that it would not be entertained until he was in custody and in front of the court. And the first opportunity that he was in custody or in front of the court was today. And so that is why we're attempting to withdraw at this point in time when he was set for trial. When I attempted to schedule it for a motion to withdraw hearing prior to today's date as well, but I was unable to get that scheduled due to court scheduling over the past couple of weeks. Mr. Elgadrab has had little to no contact with our office to prepare for trial. Additionally, he is in need of a Padilla letter with admonishment from an immigration attorney. I've had no communication regarding that with him to prepare for that or to get an understanding of what that might look like. He's had no admonishments from an immigration attorney about his potential consequences. We are not prepared to accept any offers or prepared to go to trial due to these reasons. If I was to go to trial without this information on Mr. Elgadrab, it would be ineffective assistance of counsel at that point. I think it is in Mr. Elgadrab's best interest at this point, because the attorney-client relationship has been severed due to his cooperation with our office and inability to communicate, that we be withdrawn, he be appointed an attorney by the state, and that he have an opportunity as well to get potentially an admonishment from an immigration attorney for Padilla, so that he could understand what his potential consequences are in this case. This is a case involving moral turpitude.
Yes, and with cases involving moral turpitude, if you are not a citizen, then if you are found guilty, if you enter into a plea bargaining agreement and it's a crime of moral turpitude, you're deportable. Yep, the motion to withdraw is denied. You all need to discuss. If you don't want to talk to him, what's going to end up happening if you're going to go to trial with an attorney you have not talked to. So, thank you. All right, I'll see you all tomorrow. Are you all proceeding on the motion to revoke?
The recommendation was to extend 1 year, alter and amend the conditions to an inpatient treatment.
All right, I don't know if I'm gonna do that. So are y'all proceeding on the MTR?
Yes, we're prepared to plead true to the one violation.
All right, the court is calling 2023 CR 6331B, State versus Zachary Garcia. Can I have parties announced for the record
$100,800.
for the defense?
Mick Aguilar on behalf of Zachary Xavier Garcia.
And are you Mr. Garcia?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Zachary Xavier Garcia who's placed on deferred adjudication in 2023 CR 6331B for the offense of assault on a security officer on November 6, 2023 for a period of 3 years? Is that you?
Yes, ma'am.
All right, you may proceed, state.
On or about the 23rd day of March, 2026, in Bear County, Texas, the defendant Zachary Xavier Garcia did then and there fail to comply with treatment alternative to incarceration recommendations through Bear County CSCD in violation of condition number 28.
May you plead to that true or not true?
True.
All right. By pleading true to violation of condition number 28, did you understand the court could revoke your probation, your deferred adjudication, find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 28?
Yes, ma'am.
Court will find violation of condition number 28 true. Is there a proposed agreement?
Yes, Your Honor, proposed agreement is to deny the motion to revoke, extend the probationer for 1 year and include in his conditions the ISF2 program, followed by aftercare with the intermediate sanctions program unit.
All right. So here's my question. So it's saying that he failed to comply with the TAP recommendations, and what were those recommendations?
The outpatient treatment.
And what do they mean by he failed to comply? He just said, I'm not doing it?
Oh, no, ma'am. I worked almost 65 hours a week, so it was hard to do that and go to the classes.
So probation?
Initially, this hard IOP in November, he's showing minimal effort, exception, having a non-compliant attitude and limited commitment to recovery. He did a revised TAP, and that revised TAP, so that was that. He did a revised TAP, indicated for him to for local ISF. In addition to getting some outpatient treatment, the TAP recommendation included monthly UA and documented sober support.
All right. So you're telling me that you couldn't do this because you had work and other things, and now they're still sending you to inpatient.
All right.
I mean, are they sending him to local ISF and that's inpatient?
It is inpatient, Judge. He just wants you to know he's 27 years old. Okay, I'm sorry, 28. He is responsible for 5 children. And he put work first, working a mess of hours in effort to support the kids and family. He now realizes that supervision, probation, especially in our court, is very serious, and he should have been complying. He understands now that there's a possibility of, number one, getting revoked, number two, doing an inpatient treatment that'll take him for the next 5 or 6 months to complete. Inpatient, away from those 5 kids.
Right. And I'm sorry, state, you may be excused. All right, probation, what are you recommending? Do you think this is that he'll be able to complete this?
Judge, the substance that he was tested positive for was marijuana, and that there was some failure to submit. So That's been consistent throughout his entire probation term. He says that he has completed the anger management class, but we don't have anything on file to support that. He did complete his parenting class, which gave him the current community service hours. I don't show that there's been any payment gave to his account.
You want to address that?
Oh,
You want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Zachary Garcia.
Why are you not doing well on probation?
I work long hours to provide a roof over my kid's head, my wife. I've got to pay rent, car, light, electricity, and just I have all these payments, and I also pay child support. So I have to make enough to I have to get enough hours to pay child support and have money for my family for bills and food on the table and clothes when my kids back. And it's not that I didn't want to comply, it's just that doing everything for my family is what I feel like I should do. Like I'm not a bad person. I just try to work as much hours as I can just to provide what is needed for my kids for school, at home, and just to have a roof over their head. And I just try to be a good father to my kids. Children, yes.
Which he is reporting. He has reported, he has taken the UAs, he has missed a couple, and he's had a couple come back positive for marijuana.
What is with this marijuana?
I was going to get my license to get it because I have real bad anxiety and I get overwhelmed fast. So I guess that's not an excuse, but like
No, it is not.
It helps like with the
When's the last time you used?
since November, going into November now. And I was incarcerated in January for child support, and I've been clean since. And I was given another chance, and I surely I could prove myself.
All right. Ms. Abrams, this is what I'm going to do. Deny the motion, alternate amend conditions to include intensive outpatient treatment, UA hotline for 60 days with testing at least once per week. If any classes for the intensive outpatient treatment is missed, if any UAs are missed on the hotlines, then a motion to revoke will be filed. Do you understand?
Yes, ma'am.
Anything else, Ms. Abrams? All right, thank you.
Thank you, Judge.
Okay, this is a PSI, am I correct?
It's a sentencing. It was a 2-week reset for sentencing. You gave us the option of a PSI
Yeah.
or no PSI. We chose for the more expedited approach.
No, it's just that there's a file stamp on here that says it's something else, but okay. All right. 2025 CRs 007775 State versus Jeffrey Dollar. Could I have parties announced?
Lauren Espinoza for the state.
Christopher Ramos for the defense.
And are you Mr. Dollar?
Yes.
All right, so in this case, the PSI was waived. You entered a plea. The court found there was sufficient evidence to find you guilty. The court found you guilty. According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. There's a $2,000 fine. There are no applications. This is run concurrent with 25-08-15713 CR out of Medina County.
Yes.
Any witnesses from either side?
None from the state, Your Honor.
Not witnesses, just a few exhibits for the court as evidence.
All right, any objections to the court reviewing the documents?
For the benefit of the record, my client, while in jail, has undergone various programs. Specifically, he's attended 8 sessions of AA. He's attended 10 sessions of substance abuse curriculum. He's completed the peer mentor program. He's participated in the MAT program, and he's completed 21 sessions of Narcotics Anonymous. We're asking court to take these certificates and these completions into evidence as part of the record.
All right, the court has reviewed the documents and the court will take that into consideration when passing sentence.
Yes. And all we have left is just argument, Judge, so we'll close our evidence.
All right, State.
Your Honor, we're asking that you sentence Mr. Dollar to the cap of 10 years. Mr. Dollar does have criminal history. This history does not only stem from drug cases, but also firearm possession, as well as victim cases such as the UUMV and then the instant case here as being a robbery. Mr. Dollar was sentenced to 46 months confinement with 3 years of supervised release federally, as well as 21 months with some supervised release subsequent to that confinement. Both of those federal probations resulted in revocation. Additionally, he also did straight time in both state jail and TDC in Bexar County and Amarillo in Potter County, Texas. Because of his criminal history, Judge, I believe that Mr. Dollar would not be a viable candidate for probation. He has shown in the past that he...
I'm sorry, there's no application.
I'm so sorry.
That's okay. It's been a long day. It's fine.
Because of Mr. Dollar's prior criminal history and his subsequent revocations, I don't believe that he would be a viable candidate for a sentence less than 10 years because he's already done a significant amount of time and continues to put himself in situations and make choices that show that he is not a law-abiding citizen. So because of that, Judge, we'd ask for the cap of 10.
All right, and defense.
Judge, we're going to ask for a sentence on the lower end. As you can tell from the reports, so to be clear, he knew this individual, the complainant, from a prior dating relationship. She maintained possession of an item that was his. He went about this absolutely the wrong way and the illegal way, but he went to her vehicle to try to retrieve it. She intercepted him, and in the process, he used physical force against her. It's in going over the evidence with him, and showing him how he went absolutely wrong. In reviewing the evidence, he agreed. He realized that he messed up. He took ownership of that, of breaking the law. And we're asking the court to consider the following, that I'm the second attorney on the case, but he met with me. He was forthright. We looked at the evidence, and after reviewing the evidence, we approached the court and set up this plea negotiation. And I'm mentioning that he didn't want to belabor this with a trial. He accepted responsibility immediately. So we're asking the court to sentence him on the lower end of the range because he's taking responsibility. He went about, this was not necessarily a random act. He went about trying to get some property absolutely the wrong way, but that's how this action unfolded. So for that, Judge, we're asking for the lower end.
All right. The court, as previously stated, has found you guilty. There's to be no contact with the complainant. The court will order the therapeutic community. This will run concurrent with 2508-15713 CR. That's the case out of Medina County. There's a $2,000 fine, time and money to run concurrent. Credit for any time served, no residing in households with minors, no unsupervised contact with minors, and the court will sentence you to 9 years. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Yes. Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. You understand?
Yes.
All right, and I appreciate the fact that you were using your time wisely to try to better yourself. I took all of that in consideration, okay?
Thank you.
All right, thank you. Have a good
Thank
one.
you, Judge.
Judge,
Thank you.
before, excuse, we have the complainant on Zoom for victim impact if the court will allow.
There's nobody on Zoom. If you,
Bubbles are typing. I just confirmed if she was on Zoom. She said yes, but now I have bubbles if I can have one second.
okay, if you want to, if you want her by phone,
Phone?
yes,
Okay.
and you can just do a conference call. All right, Wilkins. You want a jury trial?
Yes, I do.
All right, we'll see you tomorrow.
Okay, thank you.
He went after property he believed still belonged to him after a past relationship. In the process, physical force was used, turning the situation into a criminal case. During sentencing, he admitted responsibility but also pointed to how it all unfolded. The judge considered everything but still delivered a 9-year prison sentence.